Hello everyone, Little Smith here. So we got a bit of a important Daniel Larson update today. We actually got three because I forgot to talk about one that happened on the 10th of February. But we'll read this one first, and then we'll go through these other pages that I found. March 2026, competency ruling a new attorney. March 3rd, a month after the hearing, a month after the February 10th that I need to discuss, Judge Regina M. Rodriguez ruled that Daniel was mentally competent to stand trial. Following the 20 months of institution and competency restoration efforts, Daniel disputed that his competency has been restored. The case will finally proceed to trial at fucking last, which is set to schedule for April 20th, 2026. 420, Hitler's birthday. And apparently it's Sonicu's birthday as well. That's an important date, by the way, in the memes. He will have a pre-trial hearing on April the 9th, 2026. Okay. Dr. Caitlin Hansen diagnosed Daniel with level 1 autism spectrum disorder and a unspecified schizophrenia spectrum and other psychotic disorders. She reported that although Daniel demonstrated an understanding of the charges against him and the potential consequences, he tended to minimize the seriousness of the allegations, and she was concerned about his ability to assist his attorney in his defense. When Daniel arrived at the MCFP Springfield in December 2024, he remained grounded in his beliefs that he was dating Grace, and would constantly talk about him and Grace with staff at the Springfield and his defense. Dr. Caitlin Hansen stated that his delusional beliefs were strengthened by trolls who interacted with him during his online infamy, and that he received prison mail at Springfield containing screenshots of text messages between him and fake Graces. In February 2025, Daniel began taking antipsychotic meds, which reduced his delusions, and finally acknowledged that Grace had nothing to do with his case. However, he still aspires to be a celebrity singer-songwriter. In other words, the antipsychotics didn't really help much. Dr. Mark Mills testified that Daniel could not be fully restored to competency because of his cognitive defects come from his autism and borderline intellectual functioning, which are considered untreatable. While his delusions improved with the antipsychotic medication and structured treatments at Springfield, Dr. Mills emphasized that Daniel's autism was the controlling diagnosis, preventing him from fully understanding or interacting with his defense team, or recalling information about the threats that he made at the time. Dr. Mills also further noted that although Daniel preferred to be found competent and go to trial, his presence likely reflected cognitive limitations and tendency to agree rather than a fully informed understanding of the legal proceedings. In other words, he's going to sit there and goes, yes, I agree, yes, and that he would be unlikely to recall or explain his mental state at the time he allegedly made the threats. Daniel's mental health was also documented. The document indicated that he has been hitting himself and punching holes in the walls since at least 2011. They're going to bring all of this shit up, by the way, so by the sounds of it. and that he has been hospitalised twice for these behaviours, once in 2017 and once again in 2023. Daniel was also reported to have hit his head in the FCI Inglewood out of frustration. In 2011, Daniel's mother shared that he had a non-accidental head injury at 3 weeks old and had a seizure at 5 months. Daniel has also claimed that his mother hit him in the head with a hammer. I don't think that was actually the truth. When he was 8 years old, although the accuracy of this claim is uncertain. His IQ was reported to be 772, which is slightly above the typical threshold for a intellectual disability. Daniel no longer qualifies for a free attorney, and his previous attorney, Jared Westbrook, withdrew from the case. Daniel was subsequently reassigned to Jeffrey Filia, who has represented him in the previous year. So in the next update we're going to get is in like maybe the 9th of April, but if not it'll be after the 20th. But we are going to read these because I haven't read this one before. This one obviously is a bit of old news. Why February 10th is not a guaranteed ruling date. This was updated on the 9th. There are a lot of people who are expecting a ruling update on Daniel's competency on the 10th of February, Tuesday. However, it's probably not going to happen on the 2nd, on the 10th, and instead it's likely to be closer to this Thursday or Friday, or potentially early next week. Yes, we know it sucks. The filing deadline was for when the judge wanted the party to submit the speedy trial calculations as pictured below, not necessarily when she would rule on Daniel's competency, which obviously it was recently. Also, the judge has a trial every day this week, so her time is limited. Ordered parties shall file their positions as to the speedy trial calculation on or before February 10th. On the 10th, both parties, the defence and prosecution, must submit their views on how the speedy trial timeline shall be calculated, because the law strictly limits how long cases can be delayed, and Daniel's hearing was postponed while he was in treatment. The judge wants both sides to agree on this timeline. This helps prevent future appeals claiming Daniel's right for a speedy trial was violated. The speedy trial calculation matters that they're ruling on what is happening next. If found competent, the trial must move forward within the remaining speedy trial time, so the judge needs to know exactly how much time is left. If found incompetent, another 4-month restoration period must be allowed, or may be allowed, but the judge has to make sure the statutory timing remains lawful and properly excluded. Obviously, he was found competent, so yeah, he'll move forward. The judge requested the time calculation so that when she rules on whenever he's competent or not, she can immediately include the timeline for trial or timeline for another treatment cycle. As of 4 p.m. on the 9th of February, the parties submitted their speedy trial calculations. The judge still needs to evaluate the calculation and make a final ruling. May take a few days. This is basically that. It's basically saying get your verdict, your information in quick, because we need to get this over and done with. Edit. I'm not going to read the crossed out about edit. February 10th has now passed, and no ruling has been published as we expected. February 17th edit, 7:30 p.m. The court blue balls us once again. It has been drawn out tedious 14 days since the last hearing and 7 days since the speedy trial calculation submission. The the judge just has to decide on Daniel's competency, which in theory is an important decision. But after 2 days of hearing and reports, we'd have to imagine that she knew that she'd ruled 2 weeks ago. Right now, she just needs to put it into writing and rule on it, which can sometimes take time because she's likely to include case laws and reference to other cases in this ruling. But still, it shouldn't take an overly long time like this. Right as the result is released, we'll spread the message. Yep, we know what the result of that is. To sum it up, today, well, last time, February 9th, the parties submitted their speedy trial calculations. Now the judge is evaluating their submission and will on Daniel's competency, which may not be later this week, Thursday or Friday, or potentially early next week. We'll be the first to break the news and keep the updates available. And guess what? Updated on March the 3rd, federal judge finds Daniel Larson competent to proceed, sets trial date. So, I'll put a timestamp to this bit so you can skip over the boring stuff, the old stuff. Competent, the biggest Larson news in a very long time. After months of psychiatric evaluations, testimony from multiple psychiatrists, and evidentially hearing, Judge Rodriguez has ruled that Daniel Larson is competent to proceed for his federal criminal case. This concludes 20 months of Daniel's competency being the focus, which included 3 cycles of treatment and evaluation at Springfield. And now the case proceedings will focus on the actual 7 felony charges that he was indicted on. A competency determination does not decide his guilt or innocence. Instead, the court was evaluating whenever Daniel understands the nature of his criminal charges, comprehends the court process, can meaningfully assist defense counsel in preparing a defense. I bet you he's not able to do that. By finding Daniel competent, the court has determined that he meets the legal standards for the case to move forward towards trial or another pre-trial proceeding. So it's going to be a pre-trial, by the way. More from the judge. Dr. Hansen testified that when defendant first arrived at BOP Medical Center in December 2024, he suffered from the delusional belief that he was in a relationship with a celebrity singer. Defendant perverted on his relationship in the communications with the staff at the BOP Medical Center with his defense counsel. Defendant's beliefs in this relationship and his own celebrity status as a singer and model is reinforced by individuals on social media who encourage these delusions. For example, when housed in the BOP Medical Center, defendant received fan mail from individuals who provided defendant screenshots of conversations regarding his proposed relationship with the celebrity singer. Defendant's something easily impressionable presentation and tendency to significantly downplay the seriousness of the charges led to Dr. Hansen's concerns regarding his ability to participate in this defense. Are they just going to use the trolls as basically saying, oh no, he was groomed into it, that's okay, let him off onto the streets again? I really hope not. He does need to serve time for this. Beginning in February 2025, defendant started taking his antipsychotic medication. His psychotic symptoms improved with medication. Before taking the medication, defendant perverted on his delusions. Dr. Hansen reported that the defendant is no longer dominates interactions and conversations related to his delusional beliefs, and he has come to appreciate that the celebrity singer has nothing to do with the case, but he still thinks that he's in a relationship with her though. Dr. Hansen testified about the defendant's mental health history, records dating as far back as 2011, when the defendant was 12 or 13 years old, indicating that the defendant demonstrated executive dysfunction concerns, which defense counsel argues is required to be able to consult with your attorney. The 2011 records also indicate that the defendant has a history of headbanging. The behaviour or similar behaviour continued into adulthood. In 2017, around the age of 19, defendant was hospitalised after he hit his head, broke multiple holes in walls, and threatened to off himself because he felt overwhelmed. ECF number 82 at 8. In 2023, around the age of 26, he was brought to a hospital for puncturing himself in the face after getting upset. ID at 9. When he was in the Federal Detention Centre, before being admitted to the BOP Medical Centre, he hit himself in the face because he was frustrated. Yeah, you cannot let that thing out on the streets ever again. The Rolling Cities, that was a 2011 report where Daniel's mum shared that Daniel had a non-accidental head injury at around 3 weeks and the seizure at around 5 months. Daniel reported that when he was 8 years old, his mother hit him with a hammer at numerous points. The psychiatrists pointed out that these multiple head injuries as a cause for some of Daniel's developmental defects. There's also reports of another head injury trauma. A report from 2011 states that the defendant's mother that he had a non-accidental head injury around 3 weeks and the seizure around 5 months. Number 22 at 4. A defendant reported that when he was 8 years old, his mother hit him with a hammer. I call bullshit on that. Dr. Hansen did not conduct a cognitive testing, but in 2011 reports indicates that the defendant underwent cognitive testing in 2007 and 2009 and adaptive functioning testing in 2008. It is a note that Daniel has an IQ of 72. There's a fucking lot of this. For intellectual functioning, the standards for an intellectual disability diagnosis is 2 standard deviations below the mean IQ score, which equates to approximately 70 or below. The average of the defendant's 2 IQ score evaluations is 72. The records from 2011 indicate that neither defendant's cognitive skills nor his adaptive functioning were significantly impaired. Dr. Hansen did not testify that she would agree that the defendant has borderline cognitive functioning. Dr. Hansen also agreed that the defendant's head injuries could further exacerbate his cognitive abilities. Dr. Mill's view on his competency. There's a fucking lot. I tell you what, we're gonna get to the stuff, but we know that like they're basically saying, oh, he has this wrong with him, oh, he has that. Is basically a lot. I'm gonna put these 2 links in the description below so you can read them yourself. While the court finds both Dr. Hansen and Dr. Mills to be qualified and credible, the court gives more weight on Dr. Hansen's assessment of the defendant's competency. Dr. Hansen met with the defendant weekly for nearly a year and saw his improvement with medication, treatment, and education. Dr. Mills testified that he only spent 20 to 30 minutes with the defendant when he first met with him, which was before Dr. Hansen determined the defendant was competent. Defense counsel argues that although defendant's legal knowledge and understanding appears to demonstrate competency, because he repeats information back to the evaluators, he cannot understand complex ideas or create, implement plans. Judge Rodriguez. And there's basically some like date stamps from the 3rd of March right here. Minute order as the Daniel Larson defendant is no longer qualifies for the services of the Federal Public Defender's Office, substitute counsel has until March the 9th, 2026, that's a couple of days, to formally enter their appearance as a privately retained counsel on behalf of the defendant. Once new counsel has entered their appearance, Mr. Westbrook shall file a motion to withdraw. Please see the associated restricted minute order. On the 3rd of March, Judge Rodriguez also made it known that Daniel no longer qualifies for the free public defender Goward Westbrook assigned to him. It is unclear what has changed and under what circumstance, but it appears that Daniel has a private attorney who will be joining the case. The attorney will take over the case and work with Daniel throughout the next stages. Trial timeline. Timeline for cases like this often will end up being delayed, but the following dates are set by the judge. Pre-trial motions due 20th of March 2026. 5-day jury trial set for 20th of April. So 20th of March is the next thing. What happens next? Now that Daniel has been deemed to be competent to stand trial, the case reverts back to what was happening in May 2024, with Daniel back to facing 7 felony counts and 65 years in prison. Edit. Filia and the AUSA will have Daniel staying at Inglewood and will not be transferred. Alright. Is basically talking about is like transfers, like not being transferred, but we're gonna read about the new attorney right now. After exactly a month of complete silence since March the 3rd, the updates has been kept rolling in. As we stated in the last Leak Week article, Daniel's attorney Goward Westbrook will be withdrawing from his case, and that as Daniel no longer qualifies for free public defender given to him. In other words, the taxpayers is paying for his new defender. The new attorney that will be taking over is Jeffrey Felia. He runs a law firm based in both Miami and Denver, where he handles federal cases in Florida and Colorado districts. You can view his site here. We're not going to bother with that. We'll probably there we go. We'll bring it up just in case. Felia is most known for being a lawyer for I can't pronounce that. The leader of the Proud Boys extremist group. Fucking hell. And he's like defending a fucking extremist in court. Is this the same guy that was on that island? Ooh, Daniel's joining the Proud Boys confirmed. Right, this is a website. Yeah. Alright. Okay. That's been it for this video. It's been a long one. Yeah, I didn't read most, a portion of the other bit. I kind of glossed over it, mainly because it was like it's like court stuff, and I really didn't want to make this video that long. But yeah, the next update will possibly be a little bit after the 20th of March. But yeah, it's actually good that he's competent to stand trial, because we are interested in seeing, will he go down for the threats that he made. Is quite interesting to learn about. Like, will he be in there longer? I mean, he's been in there for like 2 years, I believe. Will he be in there for longer than Chris Can did? But yeah, that was it for this Daniel Larson update. I hope you enjoyed it. Tomorrow we'll have a weekly recap, and I will see you guys next time.